side, so she'll introduce herself. And so for those of you that are on the north side, so we look forward to it. I'm going to do just kind of a quick presentation. I just kind of condensed one that I have that's going to hit some of our Medicaid issues. And then I think we're going to switch it over to Ruth-Ann, and she's going to talk to you about VA, and then we'll answer questions about estate planning and things like that to get you guys going. So let me share this real quick. And so, all right, perfect. And so one of the things that we talk to clients about, when we're doing presentations is elder law is kind of a new area. And so we're really going to give you just kind of some quick highlights. So this is going to be kind of a little bit down and dirty. But the one things that I can tell you that we're very passionate about is helping seniors, in the families, because it's so important to make sure that our seniors are taken care of and taken care of well. So a lot of people, when they think about elder law, elder law is estate planning, but we laugh and say it's estate planning on steroids. And so we talk about probate being, death and distribution. We plan enormously. We plan for incapacity, and we plan for incapacity no matter what age. Anybody comes into the office, we plan for incapacity because we're worried about the people that are at home, the ones that are in the nursing home, and then lastly we worry about the beneficiaries and how they're going to get things, because depending on your beneficiary, it makes a difference as well. So it's really important to kind of balance the spouse that's in the nursing home or in a facility and the spouse at home. So we always look at those kind of things, and we talk about, healthcare from VA and Medicare and Medicaid type things. And then, is there money left over? How is that person going to be able to take care of themselves down the road? Sometimes we have clients that are 83. We can laugh and say 83 never an empty nester. So if you have a disabled child, there's actually some perks to having a disabled child when you start talking about long-term care. And so, and it's a transfer. You can transfer assets to that disabled child, not a problem. Medicaid says that's a good transfer. We're okay with that. Just so y'all know, there are the year 2000, there were 42 million seniors, and in the year 2050, they're expecting 78 million seniors. And by 2050, I'll be one of them. And so law school, they teach us a whole lot about death and distribution, but today we're going to talk about disability planning, because that's what we're here for. And it's truly what is so important when it comes to planning. And when you think about disability planning is very powerful power of attorneys, gifting consistent with the state planning goals, but we also have to be very careful about gifting because it makes a difference whether you're going to need Medicaid or if you've got long-term care, things like that. The ability to hire family care members and agents to provide care. A lot of times that's a hit or miss on whether or not you can do that depending on where you're going for your long-term care. The power to create and amend trust. We always have the power to create trust in our power of attorneys, and then making sure that the things that we do is consistent with what the client has wanted to have done. So for us, unlimited gifting powers is the key to long-term care planning. So you have to be able to gift everything you have. I know that sounds scary, and a lot of people are like, yeah, I'm not going to do that. But for the most part, it's important to be able to gift however much we need to gift in order to get you qualified for long-term care, whether it be for Medicaid or VA. For us, we want to have the ability in our power of attorneys, the power to create and fund irrevocable trust. So we can beat that, what they call that 5-year look back period. So Medicaid says if you transfer assets in the 5 years prior to filing for Medicaid, then they're going to disqualify you because of the transfer. So we always try to make sure that if we're going to transfer assets, we want to do it prior to 5 years if at all possible. So you can, your power attorney has the ability to transfer real estate to the spouse, the caregiver child, and transferring assets to this disabled child, because we may want to fund a first party trust in order to qualify that parent for long-term care. The other thing about having really good, powerful power of attorneys is it avoids guardianship. Guardianship, we talk to clients a lot, because having good power of attorneys saves you thousands and thousands and thousands of dollars in just the first year for guardianship. We want to have the ability to, in your power of attorneys, to force people to take them so that they use them, and really give a client the ability to protect each other. And so as far as spouses, married people, and then if you're not married, maybe if you're worried about protecting a child or children. So with your power of attorneys, you have to have a whole lot of things in there. And I have a whole bunch of things in here that I'm sorry, Ruth-Ann is going to talk about some more. And so I'm going to leave this slide for now and let Ruth-Ann kind of catch up on that. We're going to talk about Medicaid. Medicaid is a federal state hybrid, which means that the federal government funds the states for Medicaid. They have some criteria that some broad criteria, and then the states have the specific criteria on how you qualify for Medicaid for long-term care. And what most people don't realize is Medicaid is the #1 payer for long-term care in this country. It is means tested, needs based, and it is a social protection type of insurance. Just so you know, Medicaid in Texas, if you're a married couple, these are their numbers. Your home is exempt, one car is exempt, and then $120,900 is exempt. All that has to do is whether or not income is the right numbers. If your income is low, we can protect a lot more. So there's a whole lot of rules and everything that come in with this. So when people look at these numbers, they think, oh my God, I can only keep $120,900. No, you can. There's a high probability we can protect a lot more. But we need you to come in. We need you to see a good elder law attorney so that you know what you need to do when the time comes. The spouse at home, we call them the community spouse. The spouse at home can have $3,022.50 a month. And then if you have excess assets that have to be spent down, we have some really cool ways to do that as well. So it's really important to make sure that the things we can do help you the most. We talked about the 5-year look back for Medicaid. Medicaid has that 5-year look back. And Medicaid's position is if you transferred assets within that 5 years, you did it to qualify for Medicaid. Medicaid may have been the furthest thing from your mind, but for as far as they're concerned, you did it specifically to qualify for Medicaid. So there's a lot of things that we have to do to kind of help you through that. Some things we can help you through that. Some things you just have to wait out the penalty period depending on how much was transferred. So if you don't have long-term care insurance, we tell clients, please don't gift without seeing an elder law attorney. That way you're not penalized or not hurt down the road trying to pay for long-term care. So Medicaid, we said, no innocent gifting. They assume that you're trying to do something, even if you never thought about, going into the nursing home. And even though the IRS says you can get $15,000 a year without paying taxes, either one of you, Medicaid says that's still a transfer. So they kind of count that as well. So you really have to work hard to get around a lot of these rules. So for the most part, we tell clients, if you're married, we can preserve most all of your assets. If you're single, we can preserve about half of them. You can qualify as long as the income is below the cost of care, okay? We transfer only when necessary and with the guidance of an attorney, because there are things we know that we've learned that you're not going to know. And so it's going to help you to protect as much as possible. We want to give the income, as much income to the community spouse as possible, and we definitely want to avoid estate recovery. So, with, let's see, estate planning, I'm going to skip through this a little bit, and Ruth-Ann's going to pick up the rest of that. And then are we going to hold the questions till the end, Darian?
All right, trying to unmute myself. We'll take a look at the chat. It looks like it's a little quiet right now. So everyone, think of
I'm going to
we'll get back to them.
I'm going to stop my share, and then Ruth-Ann is going to talk. And then if we have some more things, then by all means, we're here to answer questions.
Awesome. Can we see my screen?
Yep.
Perfect. So I'm going to talk a little bit about the VA aid and attendance benefit. And this is a specialized benefit. When I talk about VA benefits, I always get all kinds of questions about different types of benefits. Similar to Medicaid, there's a ton of different Medicaid programs. There's a ton of different VA programs. So aid and attendance is specifically designed to help with veterans generally who are over the age of 65 or their surviving spouses, and it's designed to help pay for long-term care expenses. It's similar to Medicaid in that respect, but very different in a lot of other respects. And we're going to kind of get into that today. But I always like to start out by saying that aid and attendance is really our first line of defense. So when families come to me and we're trying to make a plan about how we're going to pay for their care, if they're eligible for aid and attendance, because it will pay for a lower level of care than Medicaid generally will, generally we're looking at Medicaid for institutionalized care, nursing home care, we're often turning first to aid and attendance. Super important though to understand that what you can do for aid and attendance is not the same as what you can do for Medicaid and vice versa when it comes to qualification. So it's very important to know both benefits. So for aid and attendance, if I can swap my screen here. There's been some pretty big changes. In late October of 2018, we had a huge overhaul to the system. So if you've heard information about aid and attendance before that time period, you definitely want to kind of check in and make sure that what you thought to be true is still true as well. This kind of got a bad rap, and there were some things that came out of it, like the 3-year look back period that we didn't love so much. But there were some other things that came out of it that were actually pretty good. Prior to 2018, we didn't have so much of a bright line rule when it came to net worth and the VA. And now we have a bright line rule. We know exactly how much money someone can have, very similar to the Medicaid program. So benefits and detriments to the changes in the rules. I always like to emphasize that spouses are eligible too. So your surviving spouse, or if the veteran is still living, the spouse is eligible for the benefit. And we're going to get into how that changes the amount of money that they receive. So they have to either be currently married to the veteran, or they have to have been married to the veteran when the veteran passed away and they haven't since remarried. So sometimes I'll get surviving spouses that will come to me, but unfortunately they've since remarried. They're not eligible for their late husband's benefits at that point. So what's the maximum benefit? What are we talking about getting? It's important to emphasize this is maximum. So you've got the numbers up there on the screen. So for those top two, when we're saying either two veterans who are married to each other and both qualify, or a veteran and a spouse, it's important to note that that means that we have to get both individuals qualified for the VA benefit. So in cases like this, it couldn't be that we had one very healthy spouse and one spouse that needed care. In those instances, we're kind of looking at the bottom two options. So to get that top maximum amount, we actually need both spouses needing care. A lot of times when we have both spouses needing care, the VA benefit isn't really going to provide enough to care for that. So it's a supplement, it's a help. It is not something a lot of times that's going to get us all the way there, because there is a maximum benefit. When it comes to Medicaid, this is where it's a little bit different. Medicaid's going to pick up all of the cost of your care beyond your income. So Medicaid would help pay better for, let's say, a nursing home than the VA benefit, because if we're only getting a little under $2,000 a month and our income is only $1,000 a month, it's not going to pay for the kind of care that we would get in most facilities. So important to know what VA can and can't do. So there's 5 basic eligibility requirements that we're going to go through, and we'll kind of take each one of these in turn. So we'll start here with qualifying service. This is the do not pass go. The very first thing that we have to check is we need to make sure that the veteran or this veteran who we're applying through for a surviving spouse, we need to make sure that they served at least 90 days of active duty, and then at least one of those days has to fall within these congressionally defined wartime periods. And Vietnam gets a little bit sticky about where you were during particular dates. Other dates used not as particular. I had a client one time that served in a post office in California during World War II, but his service was qualifying service. Doesn't mean you needed to have any type of particular job role or be anywhere specific unless we're talking about those certain Vietnam War dates. You also have to have been discharged in something other than dishonorable. So any other kind of discharge, medical discharge, honorable discharge will qualify you for service. So if your service did not meet these requirements, None of the other requirements matter. We wouldn't be eligible for qualifying for the aid and attendance benefit. I always like to talk about proving service because this is one of the more difficult parts of VA applications. When you're applying to the VA, you're dealing with the federal government and they like to take their time. One of the things that we have to do in the VA application is submit a raised seal DD-214 or an equivalent discharge paper. You do not want to send in your original if you have it. You're not going to get that back, and usually those are kind of a piece of family history. So one of the first things that I do when I have someone that comes into my office who's a veteran is I ask them to fill out something called an SF-180. It's a standard form 180. It's free. You submit it to the VA, and in about 6 to 10 weeks, they will send back a raised seal copy or 2 of your DD-214. Even if you're not eligible for the aid and attendance benefit, for any kind of veterans benefit, burial benefits, home care benefits, anything like that, you're going to need a raised seal DD-214. So if you are a veteran, your homework this week, you've got some time off probably for Thanksgiving, once the turkey's kind of settled out, go online and search SF-180. Fill that out and send that in, and in a couple of weeks, you will get your DD-214 back from the VA. And that's the first thing that we need to do. The next qualification is age or disability. So the veteran either has to be over the age of 65, they need to be permanently or totally disabled, blind by a pretty specific definition, or they're receiving SSDI or SSI, and in that case, you'd have a disability finding. So the benefit's really designed for those people who need long-term care, either by age or by condition. Then we have to prove medical necessity. So just because we're over the age of 65 isn't quite enough. We actually have to show that we need this kind of long-term care. The VA isn't just going to dole out money because maybe in a couple of years we might need the care. So we actually have to get a letter on a pretty specific form from your doctor that shows that you need assistance with 2 or more of your ADLs. And we're going to talk about what ADLs are on the next slide. It's really important to understand you do not have to live in an assisted living or in a facility. The VA benefit can pay for in-home care. And I hear all the time people say they think they have to live in a facility. You do not. So what are ADLs? What are activities of daily living? I've got this pretty neat graphic up here that kind of shows you what the 6 ADLs are. And there's also something called IADLs, instrumental activities of daily living. And those are things like shopping, food prep, housekeeping, the kind of things that, we're still able to live independently, but having these kind of supports would help. So it's really important to distinguish between it's hard for us to get to the grocery store and do our daily shopping versus it's hard for us to actually consume and eat food. They're kind of 2 different areas. And to really qualify for the VA benefit, we have to show help with the ADLs, not just the IADLs. And a lot of my families come to me when they're starting to have some issues, but we're not quite to the medical necessity level yet. But we can start doing some pre-planning at that point. Also important to understand, what I don't like about this graphic is it just shows someone being really hands-on. And there's a different level of needing help, which is what we call a lot of times standby assistance. So you don't necessarily have to be in a position where someone has to, let's say, actively take part in bathing. But if you just need someone to be around, for your safety while you're taking a bath, that will qualify us as failing that ADL. So it's pretty important to know we have to have these medical kind of underlying needs there before we can proceed. The next one is, I think, the worst rule in the VA benefit. It has to do with income. So to qualify for the maximum benefit that we talked about at the beginning, our income really needs to be 0. Now, when we talk about income, it's IVAP, income for VA purposes. So we look at the income that actually comes into our home every month, and then we subtract UMEs, unreimbursed medical expenses. So UMEs are anything basically that you're paying for that someone else isn't paying for. So this could be, I've got a pretty long list here. It could be any kind of medications. If you're paying a lot of different insurance premiums, if you've got a Part D and you've got a Part F and all these great Medicare benefits, but you're paying $600, $700, $800 a month, that counts as a UME. Any kind of care that you're paying for, anything like that. Pretty long list, and the VA defined and gave us a longer list than before as part of their 2018 change. But here's the key. These have to basically exceed or be equal to your income for you to get a $0 income and get the maximum benefit. So really, to qualify for the VA benefit, to get help getting care, you have to already be paying for the care that you need help to get. It's pretty much a chicken and egg situation. You need help paying for the care, but the only way that you're going to qualify is if you're already paying for the care. And this is, again, my least favorite part about the VA benefit because it makes it difficult to qualify for. It is a means-tested benefit. We're going to talk in a minute about the net worth requirements. And we can't have just a ton of assets and qualify, but we still have to have enough, frankly, to float us paying for our care as well as our normal expenses for several months before the VA benefits get going. So care is also pretty tricky. I told y'all we don't have to be in an assisted living or a personal care home or a skilled nurse. We don't have to be somewhere like that to qualify for the benefit. However, it's easiest to qualify if we are in a setting like that, which is kind of the grain of truth to that myth, so to speak. So if we are at home and we're getting in-home care, we just have to prove that that in-home care is actually assisting us with our ADLs, that they are licensed to provide that kind of care, and the kind of care that they're providing is actual ADL help. So essentially, you couldn't pay your housekeeper and qualify that as an unreimbursed medical expense. They're not helping with an ADL. You also have to be paying them based on the number of hours that they worked. You can't just come up with a flat fee arrangement. And this new change makes it a lot more difficult to pay our loved ones to be our caregivers. That used to be a more easy thing to do with the VA benefit, and since 2018, it has gotten more difficult. It's still sometimes possible. I strongly discourage it. It's harder to qualify, but it is a possibility, especially if they are licensed. I have a client right now whose daughter is a licensed nurse, and that situation is working out pretty well. And then the middle ground, the independent living facilities, get a little bit interesting. We can only exclude those payments as unreimbursed medical expenses if that facility is also contracting for our care. So some independent living facilities don't contract for care. You are paying them essentially to live in this community. They're preparing meals for you, but they're not bringing in any kind of extra help or extra care. Some independent living facilities, however, actually have extra care. And as part of your agreement with the facility, you can increase your care and actually have someone come in and maybe give you some of those ADL services. So that's where we kind of have to distinguish what kind of care are you getting and what are your payments going toward, and in order to see if they're actually going to be unreimbursed medical expenses. Finally, the thing that everybody cares the most about is your net worth limit. So the greatest thing about the 2018 changes is we have a bright line rule. Our number this year is $129,094. That's going to go up on December 1st. So here about another week or so, that number will actually increase for 2021. So net worth for VA is actually defined as the sum of your assets, not including your covered assets, or only including your covered assets, I'm sorry, and your income, which is pretty interesting. So it's another reason we want to zero out your income. If we're not zeroing out your income, the other income is then included in your net worth for VA, which is a little different than Medicaid. There are some key items, just like with Medicaid, that don't count. Your family, your house doesn't count. Interestingly, all of your family's needed vehicles do not count, whereas with Medicaid, we can only not count one. And then your personal things in your house, things you wear, stuff like that doesn't count. So the key excluded items, your house is the biggie, just like under Medicaid rules. Little different than Medicaid though, in that they limit the amount of acreage, which doesn't count. I'm kind of on the edge of town over here in the north side. I've got quite a few clients that are out in more rural areas, out in Tomball, Magnolia, Waller. And I actually have this come up quite a bit, that only the 2 acres around your home, unless all of the acreage is not marketable, is excluded for VA purposes. Again, pretty different than Medicaid. The biggest mistake that I see it all the time, and it happens with VA and with Medicaid, is I have families come to me and they say, Mom and Dad need care, so we put their house on the market and we've got a great offer and we're selling their house next week. We're ready to qualify them for VA benefits. That is a problem. So when we have a home, it's excluded for VA purposes. When we sell that home, unless we reinvest the proceeds within the same calendar year into another home, those proceeds become a countable resource or a covered asset, if we're talking in VA terms. So what that means is if you have a $300,000 house, Medicaid and VA treat that as if you don't own that $300,000. When you sell that and that becomes cash, now you have an extra $300,000. So one of the biggest things that I advise people is if you are thinking about needing benefits in the future, do not put your house on the market until you have talked with an elder law attorney, until you've kind of talked through how are we going to handle that? Is that really a good idea? Let's talk about some of the other things that we could do to deal with the house. So that's my word of warning on houses. Now the VA does have a 3-year look-back period. This was one of the things that changed in 2018. Interestingly though, the VA look-back period only covers what they define as a covered asset. So only those things that they're putting into your net worth. So what on earth is a covered asset? So it's an asset that's not part of your net worth. If it was transferred for less than fair market value, and if it was not transferred, it would have caused or partially caused your net worth to exceed the net worth limit. So here's what's really interesting about the covered asset definition. It essentially means that if your net worth is below the net worth limit, you can actually transfer things and be okay for VA purposes. Also means that we could transfer our residence and still be okay for VA purposes because under their definition, it's not a covered asset. But remember Medicaid. These are very different rules than the rules for Medicaid. I have very, very rarely used this strategy because something like, and maybe Kim knows the number, I saw a study a couple years ago, something like 72%, I think, of the veterans who qualify for aid and attendance will ultimately end up qualifying for Medicaid as well. We want to make sure that what we are doing is friendly for both programs. So if it sounds too good to be true, hey, we can transfer things and get rid of things, sounds like a great plan, it probably is, because remember Medicaid. A final note on trusts and annuities. Again, this is where Medicaid and VA planning diverge. We use trust planning for a lot of our pre-planning in Medicaid. If we have 5 years or more, we can utilize some pretty nifty trusts. And we also use specific types of Medicaid compliant annuities for a lot of our Medicaid crisis planning. Those are no-goes for VA. They specifically called these sort of instruments out in the 2018 regulations, and they are going to cause a disqualification for VA purposes. So here's another example of something that we could do this time for Medicaid that's going to disqualify us for VA. So really the bottom line is when we're planning for either benefit, we need to be thinking about both benefits if we are a veteran or a spouse of a veteran. So essential estate planning documents. There's 6 documents in my office that we always make sure that we have in place. They say whether you're 18 or whether you're 108. Kim said it really well. You know, we're always planning for incapacity. We want to make sure that we've got something set up whether you're a young family in your early 30s or if you're in your 80s and thinking that might be something that could happen in the near future for you. So we always start with a will. We want to make sure we've got a plan for what happens to your stuff when you pass away. It's the key part of a will. The other thing in a will that people gloss over, and I think is almost as important as where your stuff goes, is who's going to be in charge of that? Who's the executor that's named in your will? I've seen a lot of really great wills that give things to the right people, but maybe all their executors that they've named in there have since passed away. Maybe it's a will they did when they were much younger and they named their parents or their older family members and they're not with us anymore. Or maybe it's a family that's coming to me and they named their spouse as executor and now their spouse is having memory loss issues and wouldn't really serve well in that role. So we want to be thinking about our will, not just in the context of who gets our stuff, but also who's in that role of executor and other what we call fiduciary roles, trustee, things like that. Those are the two key things to think about with a will. The next is our statutory durable power of attorney. And that's kind of like our financial and legal power of attorney. And that's where we put all of that great stuff that Kim was talking about when it comes to gifting and making those pretty broad powers of attorney, particularly if we are thinking about VA or Medicaid benefits anytime in the near future. We want to make sure that those powers of attorney have that ability inside of them. Then we have a healthcare power of attorney that has a HIPAA release embedded in it. And that's so that your loved ones or the people you choose can make your healthcare decisions for you if you couldn't. We usually do a living will, also known as an advance directive, has to do with life support decision making in a pretty specific situation. We do a declaration of guardian if you needed a guardianship. And Kim talked about that a little bit. Typically, our powers of attorney are our first line defense to avoiding a guardianship. Every once in a while, they don't work. There's some strange things. I had a client a couple years ago, actually, that was experiencing some memory loss and called Fidelity and was kind of feeling a little paranoid that day and told Fidelity, didn't trust anybody in his family. He didn't want them making any decisions. He didn't do that power of attorney. And even though we had a great power of attorney in place, understandably, Fidelity froze all of his accounts. The only way we could pay for his care was having access to those accounts. We actually ended up having to get a guardianship. So the declaration of guardian makes that process a little bit cheaper, easier, and faster. Doesn't totally take it out of play, but it does make it a little bit easier if we needed it. And then lastly, we do an appointment of agent for disposition of remains, and that has to do with who's in charge and what you want to have happen to your body when you pass away. And this is a great place to put those burial and cremation requests or wishes, something I really encourage all of my clients to think about and have an answer to. If you don't know what you want to have happen, how are your family members going to know what you want to have happen? See a lot of people really struggling with those decisions because it's just not a conversation they ever had with their parents. So definitely something to think about. Kim, is there anything you want to add when it comes to estate planning?
And Ruth-Ann, I was just typing in the chat. You definitely want that disposition of remains if you're on second marriage or third or fourth. Especially if you want the kids to decide on who gets your remains or how you are taken care of. We've had a lot of litigation in our probate section on I guess you want to call them maybe stepmoms, the new wives, new husbands. The kids want, some of the remains. They may have cremated, the parents, and then they don't get them. We had one that we ended up getting involved with, that the person had been in the funeral home, I think, for almost 2 months before we got involved, because they couldn't figure out who had the right to determine what happened to this man, who was in charge of his body. And so it was ugly. And I'm thinking, that's just it's not something you want to have occur, especially it's not dignified. I mean, we want our family to be able to go and with the least amount of problems possible. And so that document is really important if you've got somebody else that you truly want to make those decisions.
Absolutely, definitely. Great point. I've seen a lot of disagreement and litigation over the same thing. It's a very emotionally charged. I don't know if you've ever had these conversations with family members, but this is what I do for a living. It comes up at Thanksgiving, and we talk about it, and it's funny. People feel really strongly one way or the other. And I've seen more surprises and disagreements over this than honestly a lot of financial things, because it's very personal and emotional.
Yeah, we've seen a lot more problems with guardianships or needing guardianships because the agents aren't doing the right things with the money. So when we're having conversations with clients, we're telling them, look, I don't care about birth order. I want to know who your best kid with money is. Who's the best kid, who doesn't have a lot of debt, who takes good care of their own money, who's doing all the right things with their money because they're probably going to do the right things with yours. And so in turn, that, medical power attorney, it may be a whole different person, so I laugh and tell clients all the time, we talk about everything in my family. There is nothing that is sacred in my family, and it usually gets done at the kitchen table. And so, we've been talking about, I laugh and say, we've been talking about, what we're going to do with my mother for years. And so, because she couldn't decide, so I think we finally have that nailed down after about 20 years of discussions. And so, but the holidays coming up is a great time to talk to your family. Talk to them about long-term care. Talk to them about what you want to have happen if you start to decline, or if you have a stroke, or if you fall and you break something like a hip, which is highly probable, and you can't go back home anymore. Because a lot of people, including some of the very lovely ladies in my family, were like, we're not going to the nursing home. That may not be an option. Staying home may not be an option. So we talk about plan A, plan B, plan C. For plan A, what's your ideal plan? Most people's ideal plan is to go in their sleep. And so, but if not, what's plan B? Do you want to stay home? And so how much money are you willing to spend to stay at home? Ruth-Ann, as just well as I do, it can cost up to $20,000 a month for round the clock care. Who's got that kind of money to pay for $20,000 to $25,000 a month for round the clock care? So, you really have to balance, do a lot of balancing act, and sometimes it's a math issue. How much can we afford to spend to stay at home versus going to a facility? And we've now started talking to our clients a lot more with the trust planning, because we do a lot of trust planning over, let's talk about that as far as disability. How much do you want that trustee to spend for your care? So we're getting a lot more people that are saying things like, I'm willing to let the trustee spend the amount of money for my care to keep me at home until it exceeds the cost of care for me to be somewhere else. So that gives them kind of an idea about what you want, but we have a lot of clients that, I had a client, she made me laugh, and she says, my kids won't talk to me about long-term care. And I said, well, did you use your mom voice? She looked at me kind of funny. I said, the mom voice, the mean mom voice that says, you will sit down and listen to me and no one's going to talk till I'm done. And she started laughing. She goes, I'll have to try that. But sometimes you just kind of have to force the issue, so we try to have a lot of fun with it as much as possible, just so to, so it's never a fun issue. So we always try to make it as fun as possible.
Yeah, that's a great point. And then, the other factor of being at home is not just the finances, but the organization. You almost have to have a care manager, and a lot of times that falls on your child. What happens when your caregiver doesn't show up that day? One of the advantages of being in a facility is that someone else is managing that facility. They're managing the payroll and the staffing and all that. And I've had a lot of kids that have taken themselves to a really unhealthy place trying to manage mom or dad's care, even though they had the finances and all of that in place. Being there every single day to make sure everything's stocked is a totally different story.
I find too that a lot of spouses, I know in my own family, my grandfather did not take care of himself, taking care of my grandmother, until he started having strokes. And then, then it kind of forced the issue for me to be involved. And then it became, a caregiver issue. And, we had private caregivers. If they called in sick, it was me that day. And back then I was litigating. I had teenagers that, I mean, my life was a whirlwind. So it could be very problematic. We finally got a good core of people that worked and did a great job, took care of them. But, it's a battle sometimes, personalities. He called me one day about 10 o'clock when we were using a private service and said, you need to make this lady go away. And I'm like, right now? He goes, I don't want to see her tomorrow. And I went, and my grandfather was the nicest man you would ever meet. I mean, I don't think he ever had an ill word to say about anything, but that one caregiver. So, and it's hard. The loss of control. When you have the ability not to drive anymore, is very painful. More so for men than women. I don't know why that is necessarily, but that seems to be the case. And in the tons of clients I've seen over the years, and so.
The other thing I always like to talk about when we're talking about estate planning is naming kids as co-agents. And Kim, you brought up birth order. I think that's a great thing too. I almost won't allow it.
Me either.
I don't think I've ever named co-agents, maybe once or twice. But I can tell you probably 30 examples of people that have come to me with children named as co-agents. And the litigation that has brought about. It is a disaster. If you're thinking about naming your kids as agents, got a great article. Just because you can doesn't mean you should. It's a bad idea. And that's always something I like to bring up when I'm talking about estate planning as well.
Yeah, we have clients that they don't want to feel like they're playing favorites. And I tell them that it's my fault, because you can't do it. So you have to pick one, and so, because I'm not going to draft it otherwise. We've had co-trustees, not very often, but and we've had to literally shut down trust, because there was no way to do, once the parents passed away, to do what needed to be done, because it doesn't work sometimes. And so I tell clients all the time that you don't have problems with individuals as long as there's transparency. The kids have to talk to each other. They have to be willing to hand out the bank statements. You know what? Here's access. Here's your view-only access to the bank accounts, because you can do that. You can set somebody up to do nothing but view accounts if you want. Add them on there. So just be transparent. It's the kids that are, or the caregivers that are secretive, that won't tell you anything, that are always the problems. And so.
Absolutely. And then the last thing I always like to bring up too, and we kind of touched on it a little bit, but a lot of times, Kim, we've got clients that we have a healthy spouse and a sick spouse, and it's important to turn that script a little bit sometimes and think about, what if the healthy spouse becomes the sick spouse, or the healthy spouse passes away first? Yep. I've actually got a case like that now. The healthy spouse passed away from COVID this summer, and it's really turned things upside down for them, because they didn't have any kind of planning for what if that spouse passed first. All this VA and Medicaid, there's awesome opportunities that we can utilize when a spouse passes away, that if we don't, we actually have somebody disqualified who is otherwise qualified for Medicaid or VA purposes.
Yeah, we're big proponents of updating estate plan. Having to tell somebody you can't leave that spouse in the nursing home, anything it's easy for us to say. Sometimes it's a lot harder for clients to do, and so, but we have to tell them this is the only way. They're getting the care, somebody's, taking care of them. It's the only way, that's, otherwise you kick them off, and then you got to start back over. And, it's not a necessarily good plan to ruin a perfectly good plan we put in place, so. And that is true. Doing good planning, after the fact is, for us, I think you probably, you as well, Ruth-Ann, it's just all part of the process. Get them qualified for Medicaid, update the estate planning, and just kind of run it all, all together so that it works. And so.
Exactly. Yeah. Darian, I think we're ready to open it up for questions if there are some. Oh, wow. Quite a bit. Okay.
Kim was answering a couple of questions.
Oh, I was planning.
Yeah, I just want to go over that to make sure everyone hears. So someone asked, how often do we need to change POAs, wills, and trusts, which we did cover a little bit. Do you want to read your response, or do you both want to touch on that again?
In my office, we update every 3 years at minimum until they hit about their 70s. And then I want to see them about every couple of years. And we do that for a variety of reasons. I like having the clients come in and just sitting around chit-chatting with them for a little while. I have found that a lot of things have occurred that they don't think about to tell us. I'll give you a prime example. A lady called, I said, hey, it's been a couple of years, come in, have coffee with me. It's time for your review. How are things going? Oh, they're going great. What have you been doing lately? Oh, nothing much. Still living by yourself? Oh, no, the grandson moved in. What grandson? Which one? And what is he doing? Oh, he's helping me. How's he helping? How's he helping you? Oh, he just makes sure things get done. Well, doesn't he have a job? Oh, no, he doesn't have a job. Well, how's he getting money? Oh, I'm giving him money. Lots of money, come to find out that she's giving this grandson, which is going to mess up lots of planning. Elder abuse is on the rise. We look for it. So we try to bring them in, because power of attorneys, the older they are, the harder they are to use. So we just kind of set a practice that said every 3 years. When you get older, every 2 years. When you hit your 80s, I like to see you every year, because then there's a lot of things we can do and can do better if we're on it and we see you and we can see the differences and things like that. So for us, it's just being very proactive in your care because we want that to occur. But because of elder abuse, a lot of times we've had clients that they've lost money because of scams and things like that. So you kind of have to regroup and look at their funds and do some planning. So a lot of times you don't want a lot of time to go by because a lot happens in 3 years. You don't think that, but I think you look back and like, God, I've been out of law school forever. It seems like a lot has occurred in all those years, so, but that's really in my office about what we do.
Yeah, I would definitely echo, I don't always update wills and trusts that often. It's good to look at them that often, but powers of attorney, every 2 or 3 years. And the thing is when it comes to this practice area, we could fight with the company about honoring a power of attorney, or we could just update it. And honestly, it's easier to update it. I've fought the fight when we need to, when we can't update it, someone's lost capacity, but if you're able to update your powers of attorney every couple of years, it's a great thing to do. And I also remind people, think about when what you own changes for better or for worse. You gain or you lose assets. If you inherit something from your parents, people are living longer. I've got clients in their 60s and 70s that have parents that are still living.
Yeah.
If we've done elder law planning for you and your parent passes away, you need to come back into our office. And then when what you want to have happen changes, you've got the grandkid now that's involved. You want to leave something to them. That's a good time to think about it. And then when your family changes, if there's death, if there's divorce, again, we're living longer. I've got lots of clients, sadly, that are starting to lose children who themselves are in their 60s or 70s, but they're losing their children now because my clients a lot of times are in their 90s and coming in. So those are the 3 times. And then we'll see what happens this next year or 2 with tax regulations. We may be doing more taxable estate planning than we've been doing in the past. So that might be a cause for everybody to come on in and look at what our planning looks like.
Yeah, I think those are some great, oh, sorry, yeah.
Hey, but I don't know, when I had someone message me a question, just when you get a chance, Deary, and I want to address that one.
Let's see. So then another question that was asked was how to have this conversation with my mother, who keeps saying that just the kids can handle it. They'll just divide it amongst themselves. She's 89 and there are 13 kids, 39 grandkids, 43 great grandkids, etc. She is strong-willed and very hard to relate these issues with her. She has both Medicare and Medicaid, received $800 a month. We provide other expenses. Do you have any tips on how to approach this conversation with family members? You did give a response in the chat, Kim, but I just want to give everyone a chance to hear and Ruth-Ann, hear your thoughts as well.
Yeah, I tell clients all the time, if you have somebody you love, you plan. And if you don't love your family, don't plan. It's the last knife you can stick in their backs. Because it really comes down to, do you care about them and what they have to go through? And so we tell them that, and then I put in the chat to feel free to have her talk to either one of us, Ruth-Ann or myself, because we've got a lot of experience in sitting down with people, and I've had people tell me that their parents won't do anything, but if you can bring them in and sit them down and really talk to them, they'll do something. They'll do some planning, get those power of attorneys in place, do those things that makes the children's life easier. Because you ask them, do you like your kids? Because if you don't like your kids, then we can just sit here and goof off for a little while. But if you like them, let me tell you why you want to do something better for them. And so
it comes across really differently too from someone else. I kind of like the mom voice. We have an attorney voice. Kim and I have done this hundreds, thousands of times. So I've had these conversations. I know how to approach them, and somehow I think, and I've experienced this, I've tried talking to my own family about it, and they don't want to listen because it's me. I'm their family member, but somebody else tells them about it and it's revolutionary. So I think that's an element of it too, just having someone outside of the situation kind of be involved.
Yeah, I think that's some great advice too. We talked about it a lot in the last session. One thing I kept saying was getting a professional involved. When in doubt, get a professional involved, because they are professionals for a reason.
I think it's that counselor at law that most people don't get, so that whole counselor session, we do a lot of counseling with clients, and not necessarily legal, just counseling sometimes, because, for me, I've been in the shoes of most all of my clients in one way or another, so life has kind of prepared me better, or unfortunately, maybe better. So it just kind of helps sometimes, and but definitely. And so.
Well, I liked one of your, sorry, Ruth-Ann.
Oh, I was just reading this question from Valerie about income, and the husband receiving $2,100 a month. And Valerie, it sounds like you don't have any income right now. So there is a minimum monthly maintenance needs allowance, the MMNA. So if you did not have any income and we qualified him for Medicaid, you would actually be able to keep a little bit over $3,000 a month, which exceeds his income. So you would actually keep all of his income to pay for the household, and he would have what we call a $0 copayment. None of his income would go toward paying the facility if he qualified for Medicaid.
I'm glad you touched on that question. I was still catching up to it.
Yeah, he's got to meet medical necessity, so have them evaluate him. A lot of times the nursing homes, depending on where you want to put them, some will come out, but because of COVID, they may not. They may have you do something from the doctor, things like that. So if you have a facility, you want a couple of things. You want to verify that they take Medicaid. You want to verify that there's a Medicaid bed available, because that's important as well. And so, because if you put them in and they're not in a Medicaid bed, they won't qualify for Medicaid. And I tell clients all the time, Medicaid beds are not rooms 1 through 10. Most facilities, and the ones you want to put them in, have 10% Medicaid beds. And so, but because they only have about 10% Medicaid beds, sometimes you have to wait for one. So it's really important to make sure that your facility has all the right things. They know you're coming in. Sometimes though, the facilities, if you're not using an attorney to qualify for Medicaid, they'll make you pay until you qualify, and then they'll give you your money back. So all those things come into play when you're thinking about Medicaid and where you're going to put them and things like that. So
that's a great point. Unfortunately, a $0 copay is looked at by facilities as a huge risk. You're saying, oh, I promise he's going to qualify for Medicaid. Don't worry about it. Let him come in, and I'm not going to pay you any money, and we'll apply and see how it goes. So it's a little bit more difficult of a path. There's ways around that. And like Kim said, I have lots of facilities I work with that they know me. I've had proven results. And so they're a little more willing to kind of help with that when you have an elder law attorney on board most of the time.
And I was going to read out one of the things Kim had said in the chat. I just liked it a lot. She says, elder law attorneys have to know more than your average estate planning attorney, because not having the right documents and not planning well could be very problematic. And I think that's another important point is even if you have one little thing wrong on the document, it may not work. So people often ask in these sessions, I wrote down it's a handwritten will. Does that work? Does that count? And I'll let you two maybe give your thoughts on that.
I just read a very interesting handwritten will not too long ago. I didn't probate it, somebody else did. We were trying to fix some things that had occurred afterwards for the client. And so, you can do a will and get it probated. If it's handwritten, it has to be completely handwritten, so, but most people, think, well, that's death. That doesn't do anything for incapacity. And so, so you'll want to be very careful about, making sure that you hit all the right elements. And there's not a lot you have to hit in a will. You just have to make sure you hit the ones that matter. It still could be problematic because if you've got to have someone to come in and testify as to the signatures and you don't have anybody that can do that, I can't remember. I mean, I may write a check 3 times a year. So people don't even see my signatures most of the time. So, sometimes it's really hard the older you get, if you don't have friends that you've known for a long time or people that can do that, is really important. And Darian, before I forget, when we're talking about power of attorneys, and I know Ruth-Ann's seen this a lot too, having just a regular attorney do a power of attorneys, they become incapacitated trying to qualify them for Medicaid, and there's none of the powers in there that we need to qualify them for Medicaid. And then you're in guardianship trying to do Medicaid planning. And so, that's why we tell clients all the time, really have a good elder law attorney look at your power of attorneys, because I see so many of them, they're just regular attorneys, maybe even regular estate planning attorneys, but because they don't do what we do, a lot of the bells and whistles are not in the documents that we need to make life easier down the road.
Yeah, I could spend the rest of the day telling you horror stories of documents. I'm sure Kim could too. Documents I've seen, and incapacity is so important because we don't know when it's going to happen, and it's not a light switch. It's not a black or white. It's not like it's there one day, gone the next. But I really encourage you, if you are over the age of 55, you need to be going to an elder law attorney to update your estate planning documents. You should not be just seeing your friend who handled your last divorce or a DWI for you a couple years ago. They're not going to be the best fit because they're not going to have the right powers in your power of attorney. We're not going to have the will set up correctly. We're going to do a trust that we think is going to protect you for Medicaid, but actually disqualifies you for Medicaid. There's some pretty crazy stuff that I've seen from people who are well-meaning, just they don't know what they don't know a lot of times.
Yeah,
we've had two Medicaid cases this year, one this year, one last year. Both people between the ages of 35 and 39. Incapacity could happen to anybody. So we, with our documents, we plan the same way. I don't care what age you come in. We all plan the same way for long-term care because we don't know.
I just saw a question come in. Should we apply for Medicaid now, even if I'm caring for him for another year or more?
You can't, and you can't apply for Medicaid until they meet the criteria. They're in the facility, they're meet medical necessity, and so you can plan for what that's going to look like to see what you need to do to make sure there's not any transfers, make sure how the money's going to look, what you can do. So it's never hurts to come in and see one of us, to kind of review that stuff, but you can't file until you go in. And so there is community-based Medicaid, but it is so difficult to get. And so there's waiting list and things like that. It's not a big priority in Texas. And so there's not a lot of money for it. And so it makes it a lot more difficult. Darian, somebody sent a message to me and it came in privately, I think by accident. What happens when parents do not want to give power of attorneys to any of their children or anyone? She's got an aunt that's 84, been diagnosed with Alzheimer's, had son living with her, and she says all her children want to take her money.
Mm-hmm.
And when the paranoia hits, it's difficult, or it may be true. I've seen a lot of kids that you think, oh my gosh, you kind of expect one kid maybe to be bad, but all of them, it kind of just breaks your heart. You know, a lot depends on whether or not with her capacity, whether it is paranoia, whether she's still capable of signing things. You know, so it's just a matter of having the doctor tell you if that's an issue or not. And a lot of them can diagnose that real quick. You know, because you can't necessarily force somebody. I mean, you could bring them into the office and Ruth-Ann and I could talk to them. I could talk to them. We can't force them to do anything. But you know, your worst case scenario, you're looking at guardianship down the road. As the Alzheimer's progresses, you're going to be doing guardianship, and that's just an expensive process. And so, yeah, and that's where the money's going to go. Ruth-Ann, you do guardianships, right?
I do, and this is how I approach these situations. I actually have a PowerPoint that's all about guardianship and really how it works and what it costs. And when I've got a client coming in, I pop that up on the TV in my conference room and we go through a PowerPoint. And I say, great, you don't want a power of attorney? Then let's talk about what's going to happen, because something's going to happen here and it's going to be a guardianship. And I'm not a huge scare tactics person. It's not my style, but when it comes to powers of attorney, I am. I have seen more problems because people didn't have a power of attorney than I have with wills. They are the single most overlooked element to estate planning. And I'm a firm believer, you know, we've got to have good, frequently updated powers of attorney.
Yeah. I think there was, I think someone had asked me about caregivers, family members being paid as caregivers. And so the VA allows it. Unless that rule's changed, the VA allows it. Medicaid normally does not, unless you are a caregiver by trade. You have to meet that criteria. So families for Medicaid don't get paid for taking care of families. Medicaid says they're your family, it's your obligation to pay for them. So my family, we grew up thinking that. And so in my family, that was just, you know, you're kind of brainwashed from a very early age that this is what was going to happen. No, I'm just kidding. We've been very fortunate in my family that the people that have needed care have been able to get care, you know, at home when they could, you know, so. And I think that was the only other one that accidentally came to me private. And so, so anyway, I just wanted to make sure those got answered.
Great. Yeah. I was thinking of a couple of things because we talked a little bit about guardianship. So one thing that I was writing down while y'all were talking is maybe not so many pros, but what could you talk about some of the pros and cons to the guardianship versus the power of attorney?
I think the only pro comes in when you've got battling family members. I've had, I'm sure Kim's seen it, what we call the dueling powers of attorney. One sibling goes and gets mom or dad to sign a power of attorney here, another sibling goes over here, and we just kind of volley back and forth. And those situations inevitably end up in guardianship court. And there actually is, at least there, some resolution. We've kind of got the buck stops here. And to me, that's the only time I can think of it being really a truly positive situation.
And we've had to do, like I said, we've had to do guardianships to do Medicaid planning, you know, but we've also had to do guardianships because of bad actors. The power of attorney agents were being bad. They were using mom or dad's money for their own benefit, you know, so, and then there, and you should hear them. Well, I'm going to inherit just my share of my inheritance. And so early in my practice, I had a couple bring their adult children in. And for the longest time, these kids kept talking about their inheritance. And I finally stopped them and said, y'all have some kind of misunderstanding here. I said, your parents are sitting here in front of me. You don't have an inheritance. And so I'm like, they're not dead, you know, so they're going to do whatever they need to do with it. And then if you're lucky, you might get some down the road, you know, but there's a lot of kids that have that conception of it's going to be my money, so I can spend it how I want to. And so you figure, you know, power attorneys, $300 to $400, get all your power attorneys done. Guardianship, $3,500 in my office, it's $3,500 retainer. If you do guardianship, the person in the estate, you better be prepared to spend about $7,500 the first year, because you got to do annual accountings. You have to ask the court for permission to do everything. As attorneys, hey, if you want me to make money, that's a great way to do it, you know. And I tell clients all the time, I'm like, hey, I don't have a problem with you dropping $7,500 to me. You can do $7,500, you can do $3,000. What's your choice? And so, because that's really what it comes down to is, you know, it's a huge, it's just the amount of money you spend on a guardianship is ungodly, when it's not necessary most of the time.
The time element is real important to talk about too. Guardianships are not fast. We do not get a guardianship, even an emergency guardianship. The court has 10 days to have that hearing. I had a true emergency situation this summer, and we were on day 9 before we could get a hearing. A lot of bad things happened in those 9 days when we were waiting on that hearing. Courts do not move quickly, especially when we're in the middle of a hurricane or a pandemic, or it seems like every year we have something come up where we've got court delays going on. If we're doing a regular guardianship, sometimes it takes us a couple months to even get into court. And in the meantime, what's happening? How's the care getting paid for? The case I told you about earlier with the frozen fidelity accounts, we literally had no way to pay for that man's care. We almost had him out on the street, and it was pretty rough. We couldn't apply for Medicaid because he didn't qualify. We couldn't access his money. So just aside from the cost standpoint, there's a lot of stress in the amount of time it takes and the amount of hoops that you have to jump through. Powers of attorney are just so much more simple.
That's great. I think one of my next questions was going to be a bit about the pricing, because we talk about how expensive the guardianship is. How much would you say it is for, I think it was the list of the 6 main documents that you had up earlier, Ruth-Ann. Would you be able to talk a little bit about maybe some of the pricing on those?
Yeah, I can. So I do most work here on a flat fee basis. So my flat fee for those 6 documents is typically $650 for an individual. Depending on what we're layering in, things like that, it may go up from there, but it starts at $650 for those 6 documents.
Yeah, in my office, it's probably closer to $750. We do a lot of extra things. I mean, we have those core documents, but we do a little bit of extra things for them as well. And so to just kind of keep everything together and do some little bit planning for some other things as well.
And then I'm sure you guys did touch on this a little bit earlier, but it's one thing I always like to mention or talk about again. It's never too early, would you say, to start planning? And then, yeah, we did talk a lot about updating documents. So do you have any more thoughts on when to start planning?
Everybody needs something. The worst probate case I ever did was a very young man. He was 24 years old, but he had just started a business with his brother. He had a home that had a home loan, pretty significant home loan on it because they had just purchased it with his wife. He had very young children. He just had a lot going on. And when we think about it, the younger we are, the more we have going on, right? We're more likely to have debt, less likely to have things paid off, more likely to have minor children. We just have a lot going on. It was the most difficult probate case I ever worked on because of that. So everyone needs a will. If we're young, we need one. If we're old, we need one. The reasons might change, but everybody needs these documents in place.
That's great. Trying to think if there's any other questions. If anyone at home is coming up with any more things, we'll probably chat for just a couple more minutes and then wrap it up soon. Let's see, I'm gonna make sure we didn't miss anything.
Oh, you know what we probably didn't talk about real quick? Life estate deeds. We're doing a ton of life estate deeds. And so life estate deeds are a deed that says if you own real estate, that the real estate is mine. If you're married, it's ours. When one of us passes, the other one gets 100% of the life estate. We can do anything we want to with that property. We can sell it, we can revoke that life estate deed, whatever. But if we still own that property at the time that we pass, here's the beneficiaries that it goes to. And then all you do when each parent passes, if they're married, file that affidavit of death that closes out the life estate. Then there's no probate. House belongs to the kids. There's no probate. A lot of times you can get away without paying a lot of creditors that way because creditors get paid in probate. So it's a real quick and easy way. We do a lot of that in Medicaid planning. Absolutely a lot of that in Medicaid planning because we never want to probate. Medicaid comes back in as a creditor in probate. if you are single, for sure. And so you never want to have that to occur, because if you do all that planning to avoid probate, to get on Medicaid, and then you got to turn around and pay Medicaid back, that's not a good plan. So we do a lot of life estate deeds. I sometimes laugh into people, it's kind of affected my probate practice a little bit because we do so many of them. But it's great. We do a ton of them. And so now there's a difference between the old they came out with a transfer on deed, one of those fill in the blank forms that you could use, and they were out for a little while. I think even the Supreme Court had them on their website. Kind of find out, and we found out very quickly, that they were the worst things they could have done. Our legislators in Austin are not real bright. I thank God every day they only go every other year. Because, while they were trying to help you to avoid probate, creditors could still get to your property for 2 years. So title companies weren't doing title insurance until the person had been dead for 2 years. So there's a whole lot of bad things that occurred. So make sure that if you're looking for this, that the two buzzwords you're looking for are life estate deed, or it's also called a ladybird deed. They've always worked for my practice, and those are the only things that we do, but it really helps a lot as well.
Definitely. Kim, you brought up a great point too. I do quite a few enhanced life estate deeds, but also the post-Medicaid planning. So if you have qualified for Medicaid, if you've qualified on your own, if the nursing home has applied for you, you still should go see an elder law attorney after the fact. I've got about 6 or 7 open claims right now, MERP claims. They're probate cases where Medicaid has come back and filed one of those recovery claims. And if one of those statutory exemptions does not exist, there's really not a whole lot you can do about it. And I will tell you, the family members are shocked. They are disappointed. We're spending a lot of money to pay Medicaid in most of those cases. We're spending years and thousands of dollars to give Medicaid some money back. So that's a great point. Once you've qualified, if you didn't use an elder law attorney to qualify, you should still talk to them about avoiding MERP after the fact.
I'm just going to read it out loud real quick. We had one more comment come in. Do you have to pay Medicaid back as a spouse if your only asset is your home? And then Kim did a quick response. And simple no, as long as you have a ladybird deed or a life estate deed prior to death.
You do get one pass. You do get one pass if you're married. So even if you didn't do that life estate deed, or ladybird deed, you get the one pass, you're married. But our position is we've had a lot of healthy spouses that have passed, that have passed before the ill spouse. And so we try to get all those things taken care of when we're doing planning, to make sure that doesn't occur. So if you didn't get the life estate deed or ladybird deed done, you get a pass. You just got to fill out the MERP form and make sure you can document how you sent it back. Send it certified mail, return receipt requested, fax it with the confirmation fax, send it well so that you've got it documented.
If you're doing proper planning, you should never have to pay Medicaid back. Anytime you're working with an elder law attorney, there are ways absolutely to avoid a Medicaid payback. You should not have to pay them back. That's one of the advantages of using an elder law attorney.
I think that's a really good point too. It comes back to always check with the experts, because they are the experts for a reason. All right, I think we'll probably wrap it up in just a sec. This is one of my last thoughts. How has COVID affected elder law? And like you kind of mentioned, it slowed down the courts a little bit. Has it affected other areas?
I think when we were chit-chatting earlier, it's affected for Ruth-Ann and I, it's affected our Medicaid crisis planning. And so I didn't even think about it in the way that Ruth-Ann was thinking about it. I was thinking about it that people weren't putting their people, because I had clients say, we're not going to put them in the nursing home if we can't see them. And then Ruth-Ann pointed out that, a lot of her clients, because they're working at home now, it's easier to take care of mom and dad. They're not going to the office, so they can keep them at home longer. Which when you can do that, that's great. It's good for the family if they can do it and do it well and not stressful and things like that. So, but for the most part, things I think slowed down, a little bit, but, in our office, they picked up in a different area. We were talking about earlier before all you guys came on, the guardianship picked up immensely in my office. through COVID, way more so than we've done in the past. And so it's been interesting. Things that I would have thought, like I said, we were chit-chatting earlier, I would have thought people would have been in getting, if you didn't have a plan in place, getting your plan in place, just in case. And that wasn't always, the case. People weren't, for about 3 months, they were sticking close to home, so.
I think there's things I'm going to keep and there's things I'm going to get rid of. We implemented a curbside signing option, and I really like that. Actually, for some of my clients with younger kids, it's been great. They've kept their kids in the car seat in the back of the car, and we've signed their wills curbside. So I think we're going to keep that as an option going forward, even post-COVID. I've enjoyed going to court this way. I miss seeing my colleagues at court, but it takes what used to be a 3-hour experience for me and makes it about a 30-minute experience for me. And I've liked that. But the hardest part, the biggest challenge I have found during COVID is so many of my clients are older and there is a technology barrier. Even if we're able to get on Zoom with each other, having the kind of conversations that we need to have, like Kim said, we leave out that counselor part a lot. We're counselors. Half of my staff has social work degrees. I joke most of the time we're part social worker, part attorneys. I've really missed that one-on-one. Now, having the mask, it's hard to, if you have hearing ear issues, it's really difficult to understand what people are saying. I think my biggest challenge has been communication with clients, and that's why I got into this area of law. I love people. I love helping people. I love that one-on-one interaction, and I will be really excited when I can go back to getting those hugs and seeing people and talking to them and really getting those conversations back.
Yeah, I miss the hugs, because we're a hugging family. I've hugged a ton of clients, coming in, definitely hugged a lot more of them going out. And COVID has made that a lot more difficult when you can't shake hands, and so, we did a lot of, when it was really bad, a lot of signings in the parking lot as well, but I've got a lot of my older clients like Ruth-Ann's is, they don't want to do this over Zoom. They want to look at you in the face. They want to be able to talk to you. They want that personal experience. And so, and to be perfectly honest with you, I thank God for that, because I like them coming in. So we do everything we can to be safe. We had our offices professionally disinfected, probably going to do it again. Just everything we could do. I've gone through more Clorox and Lysol and so, just doing everything that we can to make sure that people feel comfortable. So if they make that choice, and so then they can. Otherwise, I don't know about Ruth-Ann, but Zoom is good because I can at least see you and I can talk to you. And so a lot of my younger clients do Zoom, so it's been great. And so they don't have any problems with it. So it's been fun.
Great. Yeah, I just wanted to see kind of how it's been affecting you all, because for us at Care Partners, we've been forced to move everything completely online. It's been really interesting coming up with the different solutions, but I guess we will leave it with that. Unless you two have any last minute thoughts or anything. Just want to thank you both and thank everyone at home for asking your questions and listening and tuning in. We really hope you enjoyed all the presentations today. We talked a little bit about it earlier, but I just want to remind everyone that we will be sending out a survey this afternoon. Any comments about how we can improve this, your experience, any topics that you're really interested in, just things that you're looking for more information on. We would love to hear so we can help you with that. So yeah, just one more time, thank you again, everyone. And we hope you have a wonderful weekend and a wonderful Thanksgiving, whether socially distant or with just a couple people. But we hope everyone stays safe, and just thank you all again. There's one last comment. Basically, it's just talking about how important it is to plan ahead. So yes. All right. Thanks, everyone. Have a great day.
Bye-bye.